Okay, in our last segment for videos for today, we're going to talk about a couple different subjects for investigations having to do with financial fraud and also spousal infidelity and family law cases. The first subject is creditors attaching a cashier's check. This is Dave at AFX Search, licensed investigators in Palm Beach, Florida. So can a creditor attach a cashier's check when there's a debtor or somebody who owes money who is in possession of that check or the payee on that check? So there's a couple different ways which that might happen. The first one is, does the check have identification of the debtor, like social security number or account number, associated with the issuing of the check? Not just printed on it, but associated with the issuing of the check. Is it payment for a certain item? For example, is there an account that, let's say, was overpaid and that check is paying back the credit? Is it paying for sale of an item which should have gone to creditors, that asset? Those are things that might trigger the attachment of that check to a creditor. Remember, even if the creditor can't attach the check directly, not including that asset in a financial statement, in a bankruptcy petition, or some other creditor's acknowledgement might result in fraudulent conversion, illegal conveyance, some other type of activity that's either illegal or unauthorized. In a worst case scenario, if the creditors are part of a bankruptcy and you cash a cashier's check that you didn't disclose, that's bankruptcy fraud. It's a non-disclosed financial asset which you should have disclosed. So leaving that aside, what would be reasons that a creditor could find and attach a cashier's check? Social security number as part of that issuing of the check is one reason. A third-party endorsement. Let's say if you sign that check over to a third party, if that third party is any way part of that creditor association or group, that could trigger it back. Does it show a declining balance on any type of an account? So if you have an account that has a certain amount owed and you send the payment towards that account, other creditors might see that account go down and then track where that cashier's check came from and maybe issue something that stops payment on that check. The account may go down before the check actually clears, so keep that in mind too. Efforts to conceal a cashier's check or any asset increases the liability if you're caught. So if you just go straight ahead with moving an asset from one place to another totally legitimately, that's not going to show bad faith. If you try to conceal that cashier's check, it might show bad faith. Here's the big deal. Real big deal on any kind of a financial instrument, cashier's check, or even a personal check. There are rights of set-off that most banks have. Here's what that means. Let's say if you owe XYZ Bank $5,000 and you have a check from another bank and you deposit it into your own bank. If at any point the routing of that check goes through XYZ Bank, they can set off those funds even if they never were deposited the check. Here's another way that could happen. If you deposit that check into a joint account, the bank or financial institution can treat all those funds as belonging to one person. Set off basically means they can take any funds at any point in the processing. If it touches that institution, they can set off their debt by any assets that they can put their hands on easily. So be very careful with cashier's checks. If you're cashing them, depositing them, even paying another person, that institution can set off those funds for something else. Here's a very common scheme used on cashier's checks. If you have a cashier's check for $10,000, you don't want to deposit it into a bank. You don't want to turn it into cash because of security. What you do is you take it into the bank where it's drawn from. You have them give you $1,000 cash and another cashier's check for $9,000. It's like that cashier's check now becomes a bank account, only it's not one that's documented. And then when you need another $1,000, you bring that $9,000 check in and you use it to buy $1,000 in cash and another $8,000 cashier's check. It's like a spiraling down of the amount, and it's often used, but it's much more risky because it does show an effort to conceal. It is a risky or suspicious activity, and the bank may be required to document with an SAR report to FinCEN that you are doing a suspicious activity, and that might be need to be reported. So if you're structuring any of these transactions to conceal assets or to do a fraudulent conversion, it might increase your liability beyond what you just owed. If you only owed the place 10 grand and now you're trying to conceal assets, you may end up owing them more for penalties or fees or even court costs or attorney's fees if you're trying to conceal the movement of funds or conceal the assets. So in theory, attaching a cashier's check may be difficult, but as soon as that activity becomes prominent or passes through the wrong account, you could have issues for your creditor to take all or part of that cashier's check.